हेलो फ्रेंड्स, वेलकम टू द पॉडकास्ट। स्वागत है आप सभी का। होप होप ऑल यू आर डूइंग वेरी गुड। स्वस्थ होंगे, फिट होंगे। सो यहाँ पे काफ़ी इम्पोर्टेंट कवरेज जो डिस्कस करने वाले हैं। सो स्टार्ट करते हैं विद दैट। एंड प्लीज़ काइंडली मेक श्योर टू सी दिस वीडियो टिल द एंड। काफ़ी इंपॉर्टेंट इश्यूज मैं इसमें डिस्कस करूँगा। तो स्टार्ट करते हैं फ्रॉम द बिगनिंग। व्हाट आर द इम्पोर्टेंट थिंग्स दैट नीड टू बी कवर्ड हेयर regarding the updation of pension and the famous case we will see here. So as you know, AIBRF has been continuously and aggressively pursuing demand of updation at the various levels for the last 7 years. As per the decision taken in Central Committee of Office Bearers meeting held in Indore, January 24. So even after grant of ex-gratia amount to pensioners, AIBRF will continue to make organization efforts in coming days to achieve a demand of updation. So while sanctioning ex-gratia amount to pensioners, IBA has incorporated the following clause in the settlement dated 8th March 24. The unions associations have been demanding updation of pension along with wage revision settlement. The issue regarding updation is already sub judice before various courts including Honorable Supreme Court. The Union Association requested that without prejudice to the court cases, some ex gratia may be extended to pensioners, family pensioners, and it has been agreed that some ex gratia could be considered for the current BPS from 1st of November 2022 to 31st October 2027. So from the above it is clear that IBA has taken stand that it would examine and consider updation demand of retirees only after getting outcome of court case on updation presently pending in various courts. So in particular in the case MC Singla and others pending in the Honorable Supreme Court. So in view of above stand of IBA, MC Singla case presently pending in Supreme Court assumes importance for retirees in achieving demand of updation. So it will not be out of place to mention that the duration of similar nature had arisen in 2015 during 10th bipartite settlement when IBA refused to consider and grant 100% DA to pre-November 2002 retirees as the matter was sub judice in the Supreme Court at that time. So it is pertinent to mention that during organization efforts being made by AIBRF simultaneously to achieve demand in 2015, there were signals, feelers from the relevant quarters that 100% DA could be considered in the settlement provided retirees agree to withdraw case in 100% DA matter in Supreme Court and accept the benefit from the backdate. So despite comprehensive and lengthy debate in the matter, consensus should not be arrived between option of prospective versus retrospective, and due to this the demand could not be cleansed in 2015. So finally, with consistent and close follow-up in consequent years, it could be achieved in October 23 even after losing the case in Honorable Supreme Court in 2017. So therefore, it would be pertinent and relevant to know some important facts of MC Singla. MC Singla retirees from PNB filed the case in Honorable Punjab and Haryana High Court for updation at par with RBI and central government pension scheme. So in the writ petition document relied on which case built was clause 12 of memorandum of settlement 29th October 1993, which provides that rules will be made for commutation updation through negotiated settlement provision of regulation number 56 of pension regulation 1995, which says that in case doubt in the matter of interpretation, corresponding provision of central civil services rules may be referred. Minutes of small committee meeting dated 26 March 1993. 4. So CWP filed by 9 petitioners was dismissed by single bench A on the grounds that though it was agreed to frame rules for updation of settlement dated 29th October 1993, in which in further rounds of discussion, so this issue was not taken up and final regulations were approved without provision of updation. So provisions under regulation number 56 cannot be source for claiming a right at par with RBI or CCPS. So क्या था? They could have pressed for better rights through negotiation in the manner settlement talks provided. It would be open for petitioners to make the demand per party if they are so advised and use their bargaining skill through their association and press for leave through the mechanism provided under the Industrial Dispute Act. So there existed no vested right now for petitioners to claim benefits in the manner sought, and all the writ petitions are consequently dismissed, however subjected to above observations. सो यहाँ पे ये पूरा कंसेप्ट दोस्तों आप देख सकते हैं. अब जो इम्पोर्टेंट देखेंगे दैट इज़ टू रिलेटेड टू द एक्स ग्रेशिया. सो वेदर ग्रांट ऑफ एक्स ग्रेशिया हैज स्ट्रेंथेंड अपडेशन डिमांड ऑफ बैंक रिटायरीज और वीकन इट. So there are divergent view on payment of ex gratia to retirees. So therefore it need to be critically analyzed. So on the issue, the following important points need to be noted. In no way grant of ex gratia has debarred union retirees from raising and demanding pension updation. So in future it is stated in the relevant clause of settlement that ex gratia is being granted without prejudice of demand of updation. So ex gratia has been granted for temporary period of 5 years, indicating that it is temporary arrangement as interim relief. So grant of ex gratia has further fortified demand of retirees for updation, as IBA itself has felt need for giving additional pensionary benefits to retirees on immediate basis, even without waiting for outcome of case pending in Honorable Supreme Court, and despite filing various affidavits in court opposing updation demand of retirees. So in nutshell, by grant of ex gratia, IBA has acknowledged need for the updation. तो IBA ने यहाँ पे acknowledge करा है. So with some additional monetary benefits in the hands of retirees in the form of ex gratia, it will strengthen hands of retirees in pursuing demand of updation more vigorously and forcefully in coming days. So with this, that's all for this session.